Now, when we get to the crime of aggression, in many people's minds, it is connected to the name of Donald Ferencz, who we are just thrilled to have with us here today. Mr. Ferencz is a visiting professor at Middlesex Law School in England. But he's most well known for his passion and his commitment to defining the crime of aggression and bringing it under the umbrella of the crimes that are in the Rome Statute of the International Criminal Court. And he has spoken far and wide, when you look at his CVs, far and wide, every imaginable place on this crime, on the issue of bringing it under this umbrella, and what the kind of challenges are that it's facing today. So without further ado, I'm going to turn the floor over to our two speakers, and I'll let you figure out how the rest of the day goes.
You haven't heard us speak yet.
That's right. Thank
you might regret it.
I know I speak on behalf of Prince Zeid and as well as myself when I say it's a great pleasure and a privilege really to be here with you today, and we're delighted, both of us, to be here. For me, I have to say, honestly, this is really a labor of love, because I came up from Florida this morning. I got up at 4:15, and you wouldn't fly from Florida to Boston unless it was there. It's my love of Prince Zeid. In fact, notwithstanding what Leigh has just said to you about me and my involvement, I have to say honestly that Prince Zeid is somebody who's such an important person in the field of international law and international humanitarian law that I feel quite humbled. Truly. No, I do. And in fact, it gives me a segue to tell you how humbled I feel. It's a little bit like the story on Yom Kippur, the Jewish High Holy Day, where the chief rabbi comes in and he begins davening and praying, and he beats his breast and he said, I am nothing, I am nothing, I am nothing. And then the president of the congregation comes in next to him and begins to beat his breath. He said, I am nothing, I am nothing, I am nothing. And then the janitor comes in, and he also walks next to them and begins to beat his breast, I am nothing. Whereupon the president of the congregation turns to the chief rabbi and says, look who thinks he's nothing. Next to you. That's how I feel. Now, I have to tell you all a little background. I'm going to talk this morning, or this afternoon, about the crime of aggression, developments leading up to this very famous review conference of the International Criminal Court, which occurred in Kampala, Uganda. And then Prince Zeid will take it from there. But I want to talk to you about the crime of aggression leading up to Kampala. Whenever I talk about the crime of aggression, I like to skip around a little bit in time. I like to pay tribute to somebody who was way before Nuremberg. And we'll talk about Nuremberg. But hundreds of years before Nuremberg, there was a Swiss jurist by the name of Emmerich de Vattel, and he wrote a book called The Law of Nations. Thousands of pages, I'm afraid. I'm not going to read you all of them. But I want to read you just a little quotation about what Emmerich de Vattel said in 1758. He was talking about, quote, whoever takes up arms without a lawful cause can absolutely have no right whatever. Every act of hostility that he commits is an act of injustice. And I'm going to come and link this to Nuremberg in just a moment. He went on to say he's chargeable with all the evils, all the horrors of the war, all the effusion of blood, the desolation of families, the rapine, the acts of violence, the ravages, the conflagrations are his works and his crimes. And I emphasize the word crimes. And he goes on to list the litany of crimes, and he ends by saying, finally, he is guilty of a crime against mankind in general, whose peace he disturbs, and to whom he sets a pernicious example. This is 1758, and he's talking about it being a crime to undertake an illegal, unjust war. And he says if you do that, if you undertake an illegal war, everything you do is a crime. Every single thing you do. Now, that's 1758. I'm going to sit down and relax. After World War I, there was an effort to try the Kaiser. He fled to the Netherlands, where he had relatives. The Dutch never gave him up, I think they've been doing penance ever since. And of course, there was the League of Nations, which was formed. There were various conventions trying to outlaw, talking about the crime of aggression being a criminal act, but not really with any sanctions. A watershed development came in 1928. I don't know if anybody here has ever heard of something called the Pact of Paris or the Kellogg-Briand Pact, but the French had an idea after World War I. They approached the Americans. They had an idea that they wanted to basically get a bit of a leg up on everybody else in Europe by saying that they had a big buddy, the US, that was going to enter into a bilateral treaty with them, saying they would never make war on each other. Seemed like a safe bet. The Americans, Frank Kellogg, said, you know, nice idea, but what we're going to do is open it up for worldwide signature. The French actually were really annoyed by this. They wanted a special big buddy relationship. They didn't get it. What the world got was something referred to technically as the Treaty for the Renunciation of War as an Instrument of National Policy. Fantastic treaty coming out of World War I. People said, this is enough. The US was among the earliest signatories. It was signed by the major countries in Europe. It was signed by Japan, among others, so it really had good global reaction. When that treaty came up for ratification in the United States Senate in January of 1929, it was overwhelmingly approved. The vote was 85 in favor and only 1 opposed. And I tell you this story for a reason. I thought, who would be such a nut that they would vote against the treaty to renounce war? And I found, after some research, that in the Library of Congress, you can go and get the congressional record from 1929, and you'll see that John James Blaine, Republican senator from Wisconsin, stood up on the floor of the Senate and he said, this treaty isn't worth the paper it's written on. It's a sham. The British and other countries have reserved for themselves, through what they referred to then as declarations, today we call them reservations against portions of the treaty, the right to determine when, in their view, their interests require them to, quote, defend themselves by undertaking military action. And he saw this as an entrenchment of the British colonial, non-democratic influence all over the world, and he said, far be it for the United States to be involved in this. He recognized that the Kellogg-Briand Pact had no sanctions for countries that violated it, and it was too soft. He thought that this, and this was his words, would, quote, sow the seeds of the next great war, 1929. So I started my inquiry into John James Blaine thinking, who was this nutter? And I found out he was the best educated and most honest man in the US Senate. And there's a reason I tell you this story. Because critics of the Kellogg-Briand Pact argued in the interwar period as to whether or not it was really law. What kind of law is it where you don't have sanctions, where you have no penalties? They didn't specify personal criminal culpability. That had never been specified for the crime of aggression before Nuremberg. Now, before Nuremberg, something interesting happened. There were a series of Eastern Bloc country treaties which were non-aggression treaties. Hitler entered into quite a number of non-aggression treaties. All of these non-aggression treaties, ironically, were entered into for the sole purpose of committing aggression someplace and lining up your ducks on the other side so that you would know that you wouldn't have to be fighting up front at your back end while you were fighting with somebody else on the front. Some of the language of those very treaties from the 1930s, 1933, are echoed later in 1974 in a General Assembly resolution called 3314, which I'll say a few things about in a moment. So here we are at Nuremberg. At Nuremberg, big debate after the war about whether or not the Germans could be tried for what they called crimes against peace, whether or not this would violate what is today very often referred to as the principle of legality. That is, it must be a crime and recognized as a punishable crime. And when you do it, you can't come later and tell a criminal, aha, what you did was a crime, unless he can say, hey, I had fair notice at the time. Principle of legality, sometimes referred to as ex post facto. And one of the things that happened in Nuremberg in this debate was people said, well, the Germans violated the Kellogg-Briand Pact, an international treaty. They should have known that what they were doing was illegal. And there were 4 countries involved in trying the Nazi high command: the British, the French, the Americans, and the Russian. The British chief prosecutor for the second portion of the trial, Sir Hartley Shawcross, was involved in the closing arguments that the British made. And what he said was very interesting. He said, you know, we may not have had enforcement of the Kellogg-Briand Pact, but we had law. And he said, in fact, if the policeman fails, if there is a failure of enforcement, it is not a failure of law. And as far as he was concerned, the world had been put on notice in the interwar period that going to war illegally is in fact a crime. So they relied on Kellogg-Briand in part. There is a very, very famous opening of the American prosecutor, Robert Jackson, whose name may be familiar to some of you. Robert Jackson was a chief, not a chief justice, he was a justice on the American Supreme Court, and appointed by Roosevelt. Fascinating history. He was raised in a little town called Jamestown, New York, not far from Buffalo. He never went to law school, didn't graduate from law school. I think he may have had a year somewhere. And yet he rose through the ranks, and he was chosen to be the lead prosecutor. And he said some very important words, which I think echo right throughout and up to and including not only the Kampala Conference, but to what's happening today with the crime of aggression. Among other things, he said that 4 great nations, flushed with victory and stung with injury, stay the hand of vengeance and subject their captive enemies to the judgment of the law is one of the greatest tributes that power has ever paid to reason. Power with a capital P and reason with a capital R. He saw, Jackson saw, that after the war, the British and the Russians, by the way, wanted to line up thousands of Germans, and the High Command just killed them. He saw this as an opportunity for the world to take a step forward, to say, we've had war, it's illegal, we're going to set a precedent here now. We're going to call it crime against peace, but it's called the waging of aggressive war. And in the very next paragraph, and I want to read you what he says. I want to tell you a little quick side story. I was at a meeting a few months ago where a very senior person in the United States State Department, the U.S. State Department, by the way, is not in favor of the court taking exercise of jurisdiction over the crime of aggression because they don't want to have it be subject to scrutiny, even though the U.S. is not a party to the court. This U.S. State Department personnel, high-ranking guy, said that one of his very, very favorite quotes is from Robert Jackson. And Jackson has many quotes that are quote-worthy. And he read the following. He said, the common sense, this was part of Jackson's statement in Nuremberg, the common sense of mankind, bless you, demands that law shall not stop with the punishment of petty crimes by little people. It must also reach men who possess themselves of great power and make deliberate and concerted use of it to set in motion evils which leave no home in the world untouched. It's quite a powerful quote. But part of the reason I read it is there's a sentence that precedes that. And the person from the State Department that I'm talking about, who I have very high regard for, left off in his public remarks, quoted this quote, said it's his favorite quote, and yet he left off the sentence immediately in front of it where Jackson said the following about what was Nuremberg all about. He said, this inquest, he's talking to the judges, this inquest represents the practical effort of 4 of the most mighty of nations with the support of 17 more to utilize international law to meet the greatest menace of our times, aggressive war. This is how Jackson saw the value of Nuremberg. And after Nuremberg, Jackson wrote a report to then President Truman, talking about what was the outcome, what were the results of Nuremberg. And he said a couple of things I'd like to share with you, briefly. He wrote to Truman and he said, no one can hereafter deny or fail to know that the principles on which the Nazi leaders are adjudged to forfeit their lives constitute law, and law with a sanction. And I wasn't there when Jackson wrote this letter, it was 1946, but I believe that what Jackson was thinking was Kellogg-Briand had no sanction. Now we have a precedent, we have sanction. And he went further. He said, these standards by which the Germans have been condemned will become the condemnation of any nation that is faithless to them. And I have to say, as an American, it saddens me that the United States is seen today as a bit obstructionist relative to the crime of aggression. Before I move away from Nuremberg, which I'm going to do in just a moment, I'd like to share one other quote with you that you won't find in the transcript of the Nuremberg indictment or the judgment of the court. It's a quotation which was transcribed in the jail cell of Hermann Göring, Reichsmarshal Hermann Göring, who was basically Hitler's #2 in command. Göring was sentenced to death at Nuremberg. He cheated the hangman. He didn't want to be hung. It was not a honorable way to be killed. They wanted to be shot, as a military court-martial would have had. They didn't want to be hung, so he took cyanide just hours before the eve of his execution. But in his jail cell, he said words that I'd like to share with you, and they're chilling in my mind still. He said, naturally, the common people don't want war, neither in Russia, nor in England, nor for that matter, in Germany. That is understood. But after all, it is the leaders of the country who determine the policy, and it is always a simple matter to drag the people along, whether it is a democracy or a fascist dictatorship or a parliament or a communist dictatorship, voice or no voice. The people can always be brought to the bidding of the leaders. That is easy. All you have to do is tell them they are being attacked and denounce the peacemakers for lack of patriotism and exposing the country to danger. It works the same in any country. And those of us who remember something called weapons of mass destruction may sort of have some resonance on how easy it is to take a country into war. And of course, I believe that Göring was speaking from the heart, speaking candidly, and speaking the truth. Okay, so that's Nuremberg. What happened after Nuremberg? The Nuremberg judgment was in October 1946. In December 1946, in its very first formal sessions, the General Assembly of the United Nations adopted Resolution 95, sometimes it looks like Roman numeral 1 or I, and what they did is they adopted what's called the Nuremberg Principles. That was 1946. By the way, as an aside, not really speaking of aggression per se, but in 1984, the General Assembly adopted a declaration stating that there is a, quote, sacred right of peoples to peace. This is still something that's being worked on today. It's not related to what Prince Zeid and I will be talking about, but the United Nations Human Rights Council in Geneva is actually working today. They have a subgroup working on refining a declaration saying that it is a human right to be free from peace. After Nuremberg, the idea was adopting
free from more.
Sorry?
Not free from peace, free from more.
Yeah, I meant to say free from more. Sorry, thank you. I appreciate that. Thank you.
I'm paying attention.
Yeah, well, that's what happens when you get up at 4:15. But in any event, so after Nuremberg, Nuremberg principles were adopted, and the UN got to work on trying to codify, to develop a code, an international code of offenses against the peace and security of mankind. And it took years. They were working through something called the International Law Commission, went through various drafts, but we had the Cold War. And during the Cold War years, there was no way there was going to be any significant movement forward on developing an international criminal court itself to try these types of offenses. By 1974, there was an impetus toward defining a crime of aggression, and there is a so-called, and I emphasize the word so-called, definition of the crime of aggression, which was put forward by the General Assembly as, quote, guidance for the Security Council in 1974, which listed a whole series of acts which on their face would be prima facie evidence of an act of aggression by a state. And typically the act of aggression by a state is something which would involve state leaders, just as they tried the Nazi leadership. Aggression today is considered a leadership crime. So we moved forward to the 70s, not much happened. 1995, 96, they began to call at the UN for having a big meeting of plenipotentiaries to actually establish an international criminal court statute. In 1998, such a meeting was held over about a 5-week period, I think it was, in Rome. I wasn't there. And as I said at my opening remarks, they developed a statute for the International Criminal Court, 4 core crimes: genocide, war crimes, crimes against humanity, aggression. But aggression was put in legal limbo until the review conference. I want to say something about the Rome Statute, and I'll only talk for a few more minutes. Couple, 3-4 minutes. In the Rome Statute, there's a very interesting provision. It's at the back of the statute. Would you do me a favor, raise your hand if you've actually ever seen the Rome Statute? Nobody here? 1 or 2 people, okay. Well, you'll appreciate what I'm going to say. I'm going to put it in a very common sense context. Let's pretend you and I are negotiating a contract with each other to sell a house. And we come to the negotiation and we ask, well, do you want to sell me the shed in the back? And I say, well, I'm not really sure. Let's just make the contract for the house. And if later I decide I want to sell you the shed, we'll amend the contract so we both know what the terms are. It makes perfectly good common sense. In the Rome Statute, there's a provision. And the provision says that if we amend this statute relating to the core crimes, then as parties, all of us have the right not to be bound by any such amendment unless we take it back to our governments for ratification, like you have to ratify bills in the US. Makes perfectly good sense. Why would you agree to something now that you haven't even seen? In a criminal code, it seems very peculiar to say, well, if you're a bank robber, I'm not going to be able to prosecute you for robbing the bank unless you agree to it, unless you agree to let me do that to you. So in a criminal code, it's a little awkward, but the Rome Statute is an international treaty. It's like a big contract between players. Contractors happen to be states parties. Well, I think that gives you a bit of a background leading up to Kampala, but I said I was going to talk about 3 more minutes, 1 more left. I was part of the working group on the crime of aggression, which is a subgroup of the governing body of the Assembly States parties, which would get together a couple of times a year, and people would work during that period on what they were going to do to develop the idea of the crime of aggression. And every year it would have a meeting in Princeton, New Jersey, on the campus of Princeton, lovely Princeton, away from the city where people could pay attention to what they were doing. And on Sunday night, before the program started, people would just informally go out to dinner. But there was a group that met every time on the Sunday night. The Russian, the Chinese, weren't Americans, there were no Americans there. It was the Russians, the Chinese, the British, and the French would go to dinner publicly. We'd see them, and they used to refer to it as the P4. Usually permanent members of the Security Council are 5 of them, P5. But here it was only the P4 because the US under the Bush administration didn't come. I refer to it as the P4 Cha-Cha. Because every time they'd go out to dinner on Sunday, and on Monday, one of them would stand up and say, we don't think the court should exercise jurisdiction over the crime of aggression unless the Security Council refers a case, and it should only be with Security Council referral. That'd be the Russian. The next day, the Chinese would stand up, the French would stand up, the British, and they would say a scripted act. And it's still going on effectively today. The permanent members of the Security Council, it is feared, would like to quash the crime of aggression going forward, at least insofar as the court may have jurisdiction of its own volition to raise a case or to have state parties refer. If they want to refer a case, they all have the veto power, so they feel comfortable that they control it that way. I left out saying that we have today, of course, the UN Charter, which is also an international treaty which governs, should govern, the behavior of the states that are parties. And it says that states effectively have renounced the use or the threat of use of force, and it's the Security Council alone who can authorize states to use military force, and that unless the Security Council has authorized such use of force, nations are not entitled to use force, armed force, unless, under Article 51, they are doing so in response to an attack by another party against them. So I should have said that, because that's the framework within which we have, if you will, international law governing the use of force beyond the crime of aggression per se. Earlier when Prince Zeid was speaking, he used the phrase that the Security Council shall determine the existence of an act of aggression. And what he was referring to then, and he's referring to now, is Article 39 of the UN Charter. And so there is a provision in the UN Charter which seems to give primacy to the Security Council to determine whether aggression, an act of aggression, has occurred. I want to be sure everybody understands that. Do me a favor, raise your hand if you have not ever seen the movie The Wizard of Oz. If you've not seen it. Good. Remember? Well, you have to see it right away. Education. You can't graduate from university without knowing the scene where the wizard says to Dorothy and the Scarecrow and company, "I'll do what you want. Go get me first the broomstick of the Wicked Witch of the West, then come back and see me." Because what happened in Kampala was they adopted a provision putting in the definition of aggression, as you just heard, but with respect to the question of whether the court would actually ever be able to exercise jurisdiction, the provisions of what was adopted said that what we're adopting here about giving the court jurisdiction cannot become effective for anybody unless and until two more things happen. 30 countries have to independently ratify. Remember what I said earlier about they all have to agree to amendments? That 30 countries must deposit an instrument of ratification with the UN, and not until 2017, but in 2017 or maybe even beyond, but certainly not before, the International Criminal Court Collective, the Assembly of States Parties, the governing body, must re-vote on this either by a 2/3 vote or by a consensus. In other words, two more major hurdles, and we're going to push this into legal limbo until 2017 at the earliest. Okay, I want to give you a little bit more information about what happened since Kampala, because there's quite a bit going on, and it's a very interesting story. Now you've heard the background, that at the end of the Kampala conference, it was agreed that nothing will happen on the crime of aggression before 2017, and it will only be revoted on after 2017 if, and only if, 30 countries have decided to go to their governing bodies, their legislatures, and say, we propose that this country adopt, formally ratify these provisions and notify the United Nations, that is the place where these things are deposited. So 30 countries have to ratify it. We've come out of Kampala. Very shortly thereafter, at the behest of the United States, an international conference was held at the Grosch Center in Leiden, at the University of Leiden in The Hague in the Netherlands, where the position was put forward that what happened in Kampala was too ambiguous and too confusing, and that no country should ratify it. Now, Prince Zeid didn't go into the technical, highly complicated, and they are complicated provisions. There is some ambiguity in the law. A very well-known international legal scholar, Bill Shabas, and I were at a conference in Oxford together where this question came up, and he correctly said, so what? We here in the United States have the Supreme Court, 9 judges, 5-4 decisions all the time that come down on different sides of the law. There's ambiguity. That's why we have courts. That's why we have judges. So, I want to just share with you that there is ambiguity, that there was an effort by the United States to dissuade countries from ratifying. In reaction to such things, even before actually they had this particular conference, I scratched my head and out of basically thin air came up with an idea. I said, hey, why don't I send out an email to roughly 50 of the top legal scholars, diplomats, academics around the world who are working on this, and ask them if they would like to form a cooperative network, a venture together, a clearinghouse of ideas, communicating back and forth. And I called it the Global Institute for the Prevention of Aggression. And I got overwhelming response from some of the very, very top people in the world. One of the things that came out of it was the former president of the Assembly of States Parties, Ambassador Christian Ben Ezer of Liechtenstein, Ambassador of Liechtenstein's permanent mission to the United Nations based in New York, and I worked together to bring in some other NGOs like Parliamentarians for Global Action. And we put together a ratification and implementation of the Kampala amendments to the Rome Statute of the ICC Crime of Aggression Handbook. And this lays out the arguments and the issues for all countries to consider moving forward with ratification. So far, of the 30 required ratifications, 4 countries have ratified. I think it's Samoa, Luxembourg, Trinidad and Tobago, and Liechtenstein.
Yeah.
There are at least 30 that have already indicated their intention. Germany recently has made significant strides, and we expect them to actually deposit their instrument of ratification sometime in the next 2 to 3 months. And we were thrilled to see, shocked actually, that on the floor of the German parliament, the Bundestag, one of their parliamentarians paid tribute to the Liechtenstein mission and, quote, to the Global Institute for the Prevention of Aggression on the work that we were doing. I tell you this story because I don't know what issues you're all working on, but it's not that hard in the day and age in which we live. So there's a track some of us are on, I'm on it, to try to get the ratifications, to try to move forward with the revote in 2017. Prince Zeid just told you he knew my father wasn't happy. My dad's now 93, former prosecutor, has worked his whole life on the crime of aggression. He's disgusted because there's a terrible gap in the law. You've probably heard about the laws and customs of war. You can go into a military conflict and kill people perfectly legally if they're all suited up and have uniforms on, as long as you use the right kind of weaponry, as long as you don't take hostages and shoot civilians and shoot named prisoners. So you can legally kill people in a war situation, even if the war is itself not legal. And I want to just hark back for a moment to something that was said at Nuremberg, and then I want to jump ahead to crimes against humanity and make just a very quick comment on it, then we'll open it up for questions. I mentioned Sir Hartley Shawcross in Nuremberg. He was one of the prosecutorial team, he was a lead. And he said the following to the court, keeping in mind that he was saying, in essence, that the Germans undertook a war which itself was illegal from inception. He says the following. He said, the killing of combatants in war is justifiable both in international and in municipal law only where the war itself is legal. But where a war is illegal, as a war started not only in breach of the Pact of Paris, but without any sort of warning or declaration clearly is, there's nothing to justify the killing, and these murders are not to be distinguished from those of any other lawless robber bands. In the world in which you and I live today, there is no court with jurisdiction, no international court, to hear a case where somebody starts a war illegally and kills tens, hundreds, millions of people on the ground as soldiers. Now, there are, of course, crimes against humanity, which I'm sure everybody has heard of. That is also defined in the Rome Statute. My father was so disgusted by this gap in the law that he said, surely, as Jackson said at Nuremberg, the common sense of mankind demands that the law not stop with petty crimes by little people, but go after the people who have the power and use it, quote, set in motion evils. So my dad, because he's a former Nuremberg guy, that's in his head. And he says, there's got to be a way. Maybe we can go and say crimes against humanity can also reach those who use illegal undertakings to wind up killing people on the ground. I want to say something about crimes against humanity. In the Rome Statute, we've been talking about aggression, and we haven't really talked about its relationship to crimes against humanity. The crimes against humanity as it exists in the Rome Statute says that in order to qualify as an actionable crime, the crime must be against civilians, and there are a whole range of bad things you can do to civilians which constitute a crime against humanity, but it must be part of a systematic or widespread attack directed against a civilian population. Must be directed against the civilian population. So that means, for example, if there's a, quote, legitimate war going on, and there's collateral damage, the question comes, was it militarily necessary? Was it foreseeable? Numbers of people would be killed. Is there a balance that can be struck? And I mention it in the context of aggression, because think about it. We're talking about proportionality as being, for example, one of the type of requirements. If you start an illegal war, you undertake an illegal act, why should proportionality and collateral damage and all these sorts of things even come into play? You're killing people and you had no business being there in the first place. So that's a gap in the law that my dad is hoping to close. And in fact, I brought some things to give away, and you'll laugh when I say this. No, you won't laugh. I'm going to tell you something, then you'll laugh. These are signed by my dad, and these are little pamphlets that he's handing out all over the world. I've given these out for him because I'm a dutiful son, and he wants to know if I'll sing his song. And it's not a bad song. It's not a bad song. The world is too precious. Human life is too precious to keep looking the other way. Common sense of mankind demands that we don't look the other way. And I did say that you'll laugh because if you go on eBay and you type in my dad's name, you'll see forged signed photographs of Nuremberg with forgeries of his signature for sale. These are the real thing, and they're for free. And they can sell on eBay for about $70. Yeah, I was showing him the other day. So I don't mention that, but I'm sure these will be for sale tomorrow on eBay as well. Anyway, but anybody who's interested in getting an overview, signed by Ben Ferencz, the prosecutor in Nuremberg, you can come up and help yourself. Questions, comments?
My name is Ted Johnson. I'm a professor here in the conflict and coexistence problem. It is a problem. It's also a program. I'm curious to know about the arguments that the U.S. is making against ratification. Who's making those arguments? What are they saying?
Well, yeah. In fact, Prince Zeid and I actually talked a little bit about the dynamics. I've been invited by Noah Weisbord, who is a professor in Florida, to be part of a program there. And he said, Don, I always like to be there when you speak, he said, because you can say things that other people can't say. And I will answer your question. The United States, even in advance of Kampala, now the U.S. wasn't at the Assembly of States Party's sessions on aggression leading up to Kampala until about 12 months before, until we had a change of regime in the United States. But the initial arguments were pointing to Article 39 of the Charter, saying this is the prerogative of the Security Council to determine when crime of aggression has occurred. And there are articles, very scholarly and very persuasive articles written on this topic saying, you got to be kidding me. They don't have the right for judicial purposes. It's not a judicial determination. And as Prince Zeid said, as a practical matter, the Security Council shall determine, but they don't. So they're not doing their job anyway. But in terms of the Rome Statute itself, they've said a number of things. They've said it's ambiguous, and they've said something else. And it's a little bit technical, but I think I can put it in relatively non-technical terms. I said earlier that if we have a contract to sell a house with a shed in the back, and I decide later, hey, I want to sell you the shed, it makes sense that I have to go back to the contract with you, and you have to re-sign it for reapproval. There's a provision, which was adopted in Kampala, that says, if you are already a member of the court, and you haven't re-ratified this. But if you commit the crime on the territory of somebody that has, we're going to go after your nationals anyway. And they say, hey, wait a minute. It says in the Rome Statute in Rome, you can't go after me unless I deposit this instrument of ratification. That's what we said in Rome. So there's tension between this compromise. It forces people to formally opt out if they don't want to consent. But countries don't want to opt out. They want to say, look, if we haven't ratified, we don't have to opt out, because it forces them to publicly do something where everybody can see that they're interested in crime, not law. And in fact, I made the argument with the United States then Ambassador at Large for War Crimes, Stephen Rapp, at a meeting in Chautauqua about a year ago. I said, if the U.S. looks like we're obstructing forward movement on the crime of aggression, we look guilty as hell. When the O.J. Simpson trial was on, my dad said to me the first day, he's guilty. I said, but Dad, how do you know he's guilty? He said, it's very obvious. His defense team is trying to exclude evidence. When your client's guilty, you try to exclude evidence. When your client is innocent, you try to bring in all the evidence. And it's the same way that we're behaving. But there is a very interesting argument that the U.S. has recently put forward publicly at the Grosha Center in September or so of this past year. They said, hey, when you come to ratify the Rome amendments on aggression, the Kampala amendments, who says you can't simply ratify the portion which gives the Security Council the right to refer a case, in which case there's coverage of everybody in the world, and not ratify the part that says the court has its own authority or states have the authority to refer. So it's a very clever, very smart bifurcation for the U.S. to say, we're not against aggression, we just want to control it through the Security Council. And I will just share a personal comment. When I was in Kampala, I was contacted by the director, the executive director of the American Society of International Law. I got an email about the second day in Kampala. She said, Don, we've opened up a blog live from Kampala, but the first entry was somebody who wrote and said, there shouldn't be any action on aggression. Would you like to rebut it? Now, I did rebut it. I waited a few days. I didn't refer to the earlier article because why give airtime to some opponent's view that I don't agree with? I just wrote my own piece. And what I said, among other things, was that if at the end, all that is agreed to in Kampala is Security Council rights to refer a case, that in addition to headsets, there will be many who will also wish that nose clips would be provided. Anyway, so that's a quick summary. It doesn't do your question justice.
It helps.
Yes.
Hi, my name is Guive Mirfendereski. I'm an adjunct professor of international law at Brandeis. And I'm very curious as to why was there a necessity to reintroduce the Security Council issue in Kampala when the Rome Statute itself has already provided for the agreement between the UN and the ICC for such referrals to the Security Council.
For such I'm sorry?
For such referrals out of the Security Council.
I'd just like to amplify, as I'm sitting here listening to this, I'm thinking, with respect to the question that you asked, there are other pieces too. The bit that I just mentioned that I had published on this blog of the American Society was actually reprinted in full in a slightly longer article that I wrote for the Leiden Journal of International Law, and I'm reminded that among the arguments that the U.S. made, which are spurious arguments, not real arguments, was one that the International Criminal Court is already basically struggling, that it is, quote, and this is according to Harold Coe, a legal advisor to the Secretary of State. He made this argument publicly at an American Bar Association meeting in Washington during the same week that the ASP was meeting in March of 2010. I was in both meetings, that's how I know. He referred to the court as a wobbly bicycle. And in fact, when I was in Kampala and I wrote this piece, I was rebutting this argument. I said that I had spoken, and I had spoken, with very senior people at the court, asking them what their view was on that. And I quoted, actually I can tell you who I quoted, although I didn't quote her by name, Silvana Arbia, who's the registrar of the court, an Italian woman, very lively, who said to me, "That's ridiculous." And I quoted her in rebuttal to that particular argument. But that was also part of the shtick that the U.S. was throwing in on this. Anybody else? Yes. I'm going to try back here, and then we'll come back to you. Yeah.
Hi, I'm Inbal. I'm a student in the Coexistence and Conflict program, originally from Israel. Clarification, just to make sure I understood correctly, that when you say the crime against aggression, you're talking about the idea that there is no legitimate act, there's no time where there is a legitimate war, or the whole process was to understand in which cases it is legitimate, in which cases it is not. So that's a clarification question.
I used to work for many years as a senior tax executive for big multinational companies, so I had a lot of experience reviewing contracts and documents. And I used to tell people on my staff, don't just look at what's in the contract, look at what's not. Don't just review what's there. Ask yourself the question, what's not there should be. Something big missing from the Rome Statute definition of aggression. I was involved a number of years ago in a case in the UK where a number of people broke into an air base when we began bombing Iraq. They tried to disrupt the bombing by smashing up some planes. And they claimed what's called the necessity defense that exists in a lot of criminal jurisdictions. You can take the law in your own hands and do something like smash a window that's normally illegal if you're trying to save somebody who is, being mugged inside. This type of thing. Necessity. There's no policeman there. Nobody's left but you to act. And I mention it because the question of what is a legitimate action, which on its face looks like a prima facie conduct that would qualify as a, quote, potential act of aggression. When you think you're doing something legitimate, okay? Humanitarian intervention is one of the phrases. In fact, I once heard somebody from the U.S. State Department misspeak, that tripped over the words and called it humanitarian invention. And we all kind of chuckled, thinking, yeah, there's a lot of that too, especially where there's oil on the ground. But the Rome Statute is missing the question of mitigation. It doesn't really properly address. It's in the statute definition, really, if you look at it. It said it must be a manifest, manifest violation of the UN Charter as to gravity, scope, and character, I think it is. So what does that say? It says to us that if there is some action which on its face doesn't look right and may not be right, that perhaps there are mitigating circumstances that the actor could bring in as evidence, which would be exculpatory. But other than that, I think if the question is, well, who says what's legitimate and not, it's really up to the judges in theory to make that determination, hard as it may be.
Yeah, my name is Oumar. I'm a student here in the Coexistence program. Well, this is not a political question, but I am a little bit curious about what you have been doing. What's your next step towards convincing the U.S. authority to ratify the Rome Statute? Because recently ICC targeted African leaders, and from your lecture I see that you have been too much in contact with African countries. But I'm curious about what you are doing here, because the U.S. is much more involved in peace building and development around the world. And ICC is a way to prevent conflict, to solve conflict. And still, you have written books, published many things, but the U.S. is still on its position.
Okay.
What's your next step?
Okay, I'd like to summarize the U.S. position on the world by quoting from an unlikely source. I was at, and I wish I knew the name. But
I've got to get out of camera shot.
No, you'll be okay. I'm not naming names. I was out at the United States Air Force Academy in Denver. I think it's, well, not Denver, it's right near Denver, I believe. And there was a break in between lectures. And one of the cadets, now these are the guys who are going to be the officers, the officer corps of the United States Air Force. I thought these guys would be my country, right or wrong, gung-ho. I was delighted to find out that these are thinking human beings. One of these cadets said the following: the U.S. wants to make the rules for everybody in the world, but we don't want to play by those rules. Now, that was, I'm quoting somebody else, so I can say these outrageous things. But in fact, you asked at the beginning of your question, what is happening in the U.S. relative to ratification? There is nothing meaningful happening because the U.S. will not ratify. It would be a political, tremendous waste of capital on this administration to undertake an effort to ratify something which could never get through the U.S. Senate. It took 40 years for the Genocide Convention to get through. It wasn't until Ronald Reagan, 1984, that it actually got through. So, what does it mean? Well, the U.S. is trying to be much more supportive, and in fact is supporting efforts of the ICC to investigate, to share information where they can. I know this for a fact. It's not a secret. You pointed out that there is a perception among some that the ICC is focusing all of its efforts on Africa.
Yes.
The implication, and I've talked with other people about it, and I use the expression, is the ICC a game of white man's Western justice being imposed, essentially another tool of the Western colonial powers on the rest of the world? I raise it as a question. Let's keep in mind, the people on whose behalf these cases are being brought are African victims. African victims who are the first ones who have been so terrorized by some of these players that the court itself, not in a vacuum, but because, for example, Ugandans referred the first cases. These were referred by the African countries, and there are others who have been similarly likewise followed. There's a conference coming up which I'll be attending in about 2 weeks' time in Arusha. It's a question on what is the African perspective on the ICC. In fact, I'm there to ask the question, not to answer it. Illegal use of force, does it matter to Africa? I think the question is an important one, and it's a very good one. And in fact, ironically, the fact that the United States has not been a state party has been a good thing for the perception of the court, because if it were, everybody would say, this is just another tool of the West, the tool of the United States. And many of us who have been advocates for the ICC have been, in some sense, relieved that the position of the U.S. has been very arm's length. But it's getting closer now, as it should be, and we're very, very pleased with that. We, I'm told, unfortunately, are out of time, but one last thing I want to say. For anybody who would like one of these, I would appreciate if you could stay for just a moment, quickly, because we have to vacate and we have to be elsewhere, and take a photograph with myself and Prince Zeid. It was a specially autographed one from my dad. So before you sell them on eBay, you can have your picture taken. And I want to show this picture to my dad because it'll give him great joy. You're going to be in the picture too. Okay, thank you very much.